Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and I want to talk to you about what do you do when maybe you get a letter from a debt collector, maybe you look at your credit reports, you see a debt collector, and so you send a dispute letter or a validation letter, basically saying, hey, I dispute this debt, or if you do it the way I suggest, you say I dispute any debt. And then you ask the debt collector to give you some stuff. It may be statements, it may be the purchase agreement, it may be the contract, whatever it is that you think is reasonable, you ask that debt collector and they don't give it to you. What do you do at that point? Well, there's a couple options. One, if you think that they are required to give you what you ask them and they violated the law, the FDCPA, Fair Debt Collection Practices Act, then you could always sue them. I will tell you, judges are pretty, I think, lenient and lax about what the debt collectors have to give you. Okay, so usually that's not a great option. Now, the second option could be you look at your credit reports and see, did that debt collector, after receiving your dispute letter, update your report? Okay, so the balance has been updated, the status has been updated, but they do not mark it as being disputed. Well, then you would look at suing the debt collector under Section 1692E8 for the failure to mark your account as disputed. But what if that doesn't happen, or what if you want to go a further step? Well, a further step you can take is to send what's called a refuse to pay or a cease communications letter. Those are the same thing. And you say to the debt collector, in essence, look, I asked you for some stuff, you refused to give it to me. Without that, I just refuse to pay this debt. Please close out my file. And then they're faced with a choice. What do? Now, under the law, they're not supposed to communicate with you except in some very small circumstances. They can't send you a collection letter. They can't call you. They can't write you and say, you owe this money, you better pay it. But what we find is that sometimes they'll do that because they realize that they overreached, right? When they refuse to send you reasonable things, and now you say, because you didn't send that to me, I'm not going to pay you. Then they may go, oh, you know what? Go ahead and send them the documentation. That's violating the law because you told them, cease communications with me. Or again, refuse to pay. Exact same thing. So now they have violated what's called Section 1692CC. So the failure to mark an account is disputed on your credit report is 1692E8. This is 1692CC. That's the communication with you when you've told them, I don't want any more communication. And so that gives you the ability to at least look at suing them. So again, three options when they don't validate. Maybe you can sue them. Maybe they did not mark your account as being disputed, and so you can sue them under Section 1692E8. Or you send them this refuse to pay, cease communications, and then see if they follow the law. Now, there's nothing magical about these, okay? If you want a template, you can reach out to us, and I'll put a link below. You can just go to my website, alabamaconsumer.com. It's the contact form on there. Just fill that out and say, hey, I was watching your video. I'd like the template for a dispute letter and a refuse to pay or cease communications letter, and I'll send that to you in a Word. Okay, you guys have a great day, and thanks for watching. All right, bye-bye.